action. So, yeah, I'm Paul Rabalais, an estate planning attorney. Here's what we're going to talk about. At what age should you get serious about estate planning? So, quick intro, I'm estate planning attorney Paul Rabalais. I've worked with thousands of clients over my career, helping them get and keep their estate legal affairs in order. Make a long story short, after I earned my law degree, in fact, my undergraduate degree in finance, my law degree, then I earned a master's in tax law from Boston University School of Law, started my legal career in 1991 in my home state of Louisiana. Several years ago, after this YouTube channel took off, I started getting requests from people all over the country to help them put their estate legal affairs in order. So now with our co-counsel network we have in place, we're able to help people all around the country. People often start the process by clicking the link in the description of this video to request an initial Zoom meeting to discuss the design of your estate plan. Okay, so why this video? People tend to procrastinate estate planning for any number of reasons. One, they have to face their own mortality. Two, they have to sometimes make decisions that are difficult. Some people are concerned about the expense of getting their estate in order. But the problem is life comes with uncertainties. We don't know how long we will live. We don't know if at some point during our lifetime we may get to a point where we can't handle our money, can't make our medical decisions. We don't know how our children or other heirs will turn out. Will they be financially mature enough to handle a lump sum? Lots of other uncertainties about life that sometimes require us to put things in place and then change those things. But what I want to do is I wanted to give you my experience of at different phases of people's lives. When do they get serious about estate planning? When are they not serious? At what point in their life are these issues most important versus those issues? Let's just jump right in. I'm going to take it chronologically and start with the brand new adult, and then we'll work our way through early adulthood, kind of midlife, pre-retirement, and then retirement and beyond. So let's start with the really young folks. Great to see you, Larry from California. I really don't feel like I'm giving a live stream until I know that Larry's in the room. So great to see you here. Let's start with the brand new adults. What kind of estate planning issues do they address? I'll call, and look, these are all very generalities, but I'm going to call a brand new adult as somebody who, let's call it age 18, the age of majority in most states, to age 23. These people are really young. I feel like the last thing an 18 to 23-year-old is thinking about is putting their estate legal affairs in order. But what I have dealt with, more than a handful of times for sure over the years is when, and I'll just use this as an example, when the recent high school graduate who might be 18 years old is about to go off to college, they're going out of state, they're moving away from the home. A lot of times the parents will contact me and say, you know what, my child is going out of state to college. I feel like I need to have power of attorney for that child just in case I got to handle something for them. They're not the most responsible. Sometimes they get themselves in a little bit of a bind financially. I might need to talk to their bank or their school or their doctor in order to get things straight, and I need a power of attorney for them to do that. So that's kind of common, actually, and really probably not a bad idea for parents who have children going off to college, is the parents initiate some estate planning, which usually involves those 18-year-olds, those 19-year-olds putting powers of attorney in place, maybe naming the parents as what we call the agents on a power of attorney, just in case those parents need to transact something for their young adult child. Because normally, if you don't have a power of attorney, or that 19-year-old doesn't have a power of attorney, and mom's trying to call her daughter's bank, the bank's going to say, sorry, mom, we can't talk to you about your daughter's account. But if mom has power of attorney, that makes it much more likely that mom's going to be able to take care of things for daughter. Of course, the child has to consent to having power of attorney and all that stuff, but we see that a good bit. All right, so that's the brand new adult estate planning. Next, let's move to that what I'll call the early adulthood. I'm going to call that ages 24 to 35. Okay, now we got some people who are starting to get married, starting to enter into permanent relationships, starting to have children. That's a big one. Again, I don't see those 24 to 35 year olds actively initiating estate planning nearly at the level that the kind of retirement group does for obvious reasons. The 24 to 35 year old, even if they're a parent, they just kind of think they're going to live forever, and estate planning is something that they can put off. Now, I will say I've done this for a lot of early adulthood, 24 to 35 year olds, especially if they have children. They might be married, they might be divorced, but if they have children, and it's quite frankly really important for those parents of young children to get legal affairs in order for a couple of reasons. One, most parents feel strongly about who they'd want to raise the children if the parents pass away before the children reach the age of majority. That's a big one. Of course, it's a big one for the moms out there, also big for the dads too. But moms tend to have very strong feelings about who should raise the children. Also, sometimes, parents will say, I would want my parents to raise my kids if something happens to me before my kids are 18. Some parents will say, I would want my sibling to be able to raise my kids. So putting the estate planning legal documents in place to establish that guardianship for the minor children is really important, because if they don't do it, then it's up to a judge to pick somebody, and it's up to a judge to determine that, what's in the best interest of that minor child who no longer has their parents. A judge picks that. So you get to do that. If you're a parent with minor children, you get to designate who you want to be those, what we call backup parents for your children. Anytime we do estate planning, and we know that our client has one or more minor children, 100% of the time, we're going to incorporate those guardians for the minor children in the estate planning documents. In addition to just naming guardians, if you've got minor kids, then you don't want to just leave assets to them. If you pass away without a will, or with a will that just leaves assets to your minor children, it's going to be a legal mess, because now, the insurance company, the financial institution where your IRA is held, your child can't inherit in their name. They're a minor. So if you leave things either because you've never done any estate planning, or you have, but you just left things outright to your minor children, then when you pass away, there's going to be more court proceedings, more guardianship proceedings, where a judge has to pick a guardian for the minor children, and then the guardian oversees the handling of the minor's inheritance. And then on the minor's 18th birthday, it all just gets dumped in their lap. So that's why it's so important for parents with minor children to either in their wills set up what we call testamentary trusts, or in their living trusts set up subtrusts, so that if the parents pass away before the children are old enough, responsible enough to handle things for themselves, then it's real common for maybe parents to say, if we both pass away before our children reach the age of, maybe they'll pick something, age 25, then maybe they say, we'd want the father's brother to be the trustee of a trust, and have that brother manage the assets for those young children and use it for the children's typically health, education, maintenance, and support. And then when the children reach the age of 25, then that trust is no longer necessary, and then the children can take over from there. Age 25 is just something I picked out of thin air. Some people say, I wouldn't want my children to get their hands on the balance until they're 30. Some people say, let's give it to them in stages at 25, 30, and 35. Some people say, let's let the trustee determine when our children are ready to have it. We trust the trustee. So there's a lot of options on, if you have minor children and you leave things through your will, a testamentary trust, or through your living trust, a subtrust, there's just a bunch of different ways you can set that up as to when your children can control that inheritance, and what those assets can be used for up until that time. So that's typically the early adulthood major issues. They're married, and they may want to take care of their spouse, because I've seen some people who they get married, their own property, maybe they have some inherited assets, and they do no estate planning. Something happens to them, and the surviving spouse is left out, gets nothing under the intestacy laws of that particular state. So with the estate planning, you can leave things to your spouse, you can leave things to your family. You get to control what happens when you pass away. So, but I would say big two issues with early adulthood, 24 to 35, especially if you're married and you have kids. It's one, naming who the backup parents to your children are, and then two, making the proper provisions so that you leave things to a trust for your children, so the inheritance doesn't get tied up in the courts and they don't get a lump sum amount when they're 18. And then in addition to that, you got to go back in and you've got to change your beneficiary designations on your 401k at work, on your life insurance. Because yeah, you may name your spouse as your primary beneficiary, but you really shouldn't be naming your children as the contingent beneficiary. You should be naming a trust for your children as that secondary or contingent beneficiary after your spouse, so that your responsible brother can manage all of that money on behalf of your children until your children are old enough and responsible enough to handle things for themselves. That's the early adulthood, age 24 to 35. Still, I'd have to guess that if I've had 10,000 clients over the years, which I've probably had somewhere around that number, I would say 90. Well, I would say maybe out of 10,000, maybe 100 to 200 have been in that brand new adult and early adulthood range. So let's get into the more volume here, which is the midlife. I call it the midlife people. Let's call them, they're somewhere between 36 years old and 50 years old. These people, they're not extremely highly motivated to get their estate planning in order, because they've still got other things in mind. They're still on the mindset of accumulating. They're working. They're buying homes and trying to get them paid off. They're socking money away in their 401k and their retirement funds. Yes, they're probably divorced. Married, but they may have been divorced. Now they're 36 to 50 years old. They may even get remarried. But at that 36 to 50, still probably have some children that are young. Certainly if you're 36 and you have kids are likely to be young. At 50, this midlife range, 36 to 50, at 50, you may have a child or two starting to reach or has already reached the well over the age of majority, but still the jury's still out on that not only that 15-year-old, but maybe the jury's still out on that 22 or 23-year-old. How are they going to handle a lump sum of money if they inherit in the future? So these people in midlife, they're still kind of trying to figure it out. They're accumulating, they're saving, they're paying off their homes, their children are starting to grow up. And so, children might be 15 to 25, something like that. And so maybe a child or two is getting married. Maybe a 50-year-old could have a grandchild. I'm 59 and about 3 weeks away from my first grandchild. But you have kids who are either older minor kids or young adult kids, and they haven't figured it all out yet. So you're a little worried about leaving them a lump sum of inheritance. So you kind of like the idea still of leaving things in a trust for them, at least maybe until they reach a certain age or certain ages, because you're concerned about maybe a 25-year-old inheriting $1 million, going out and blowing it, where that $1 million inheritance could really make their entire life easier if they handled it appropriately. So some of the difficult decisions for those people in their midlife, 35 to 50, are, how do we leave it to our kids? Do we let them have it at a young age? Do we not let them have it until they graduate from college? So a lot of pros and cons to putting those kinds of restrictions on a child's inheritance. And then if that 36 to 50-year-old, gets married and then gets divorced, whole new set of issues. We're always going back and changing the estate plans of people who get divorced. So got to make sure you do that if that's an issue of yours. So that's the 36 to 50 midlife. Next, Now we're going to start getting a little bit serious here. Next, let's talk about I'm going to call it the pre-retirement people. You're maybe in that range of 51 to 65. That's where I am. I'm 59. I'm almost smack dab in the middle of 51 to 65. I'm 59. And so the issues that those people face, they're starting to realize that they're not going to live forever. Perhaps people in that pre-retirement 51 to 65, perhaps one or both of their parents have passed away. And so they've gone through the settling of an estate. Maybe the settlement of the parents' estate was a piece of cake. Maybe it was a disaster. But at least now those people 51 to 65 who have lost one or both of their parents, or maybe they've seen it because a spouse or significant other of theirs has lost one or both of their parents. So now they've got some experience, at least on the estate settlement side, of seeing some estates of close loved ones get settled. And I genuinely know that impacts a lot of the decisions that people make. Some people will come to me, they're 60 years old. They're like, Paul, my dad passed away a year and a half ago. And since my dad died, my brother, he doesn't speak with me. He doesn't return my calls. He doesn't return my emails. He was the executor. I'm not sure what he did with the money. Can't get any information out of him. I got to set things up so that the right people are in charge and this thing goes really smooth for my family, because I don't want what happens to our family. I don't want that happening to my family. And so then, they're usually all about setting up that living trust, avoiding the probate, designating the right person or people to handle things when they pass away, when they're incapacitated. But I also see some people who will tell me, Paul, I'm 60. My mother passed away a year ago. It was a piece of cake. And boy, everybody got along great. There was great communication and things were really easy. I think I'm going to do exactly what my mother did. So people's experiences in estate planning and estate settlement, without a doubt, have an impact on some of the decisions that they make. I had a conversation yesterday with a gentleman, and he was like, Paul, my parents, they didn't have much, but they had to go in a nursing home. They lost everything. And so that was his driving concern. He didn't want to lose everything if he went into a nursing home. He was still relatively young for nursing home purposes. He was in his early 60s. But that was his driving concern. And he really didn't have a need to try to qualify for Medicaid because he had enough resources of his own to cover that expense. But that's just another example of what people experience in their own family, particularly with their parents and with their grandparents. It does impact how they want to set things up for their family. So those pre-retirement people, 51, 65, maybe they lost a parent or two. Probably a good idea now that their kids are adults. They want to review and update those beneficiary designations. Now they've accumulated some assets. Now this tax planning, at 51 to 65, you've been paying income taxes your whole life. You've been paying capital gains taxes when you've sold stuff. And so you're just kind of sick of taxes, and you want to make sure that your estate doesn't get smacked with taxes. So with those people 51, 65, there's lots of discussions about minimizing capital gains tax, minimizing the estate tax when they have some wealth. Also conversations about what to do about the income tax, particularly on traditional IRAs, traditional 401ks, because those are taxable to the beneficiaries. So tax planning becomes a bigger part of the estate planning conversation once people get to those kind of 50s and beyond. They're thinking about retiring. They have some young kids who are starting to get married. Maybe they had a child who already got divorced. So making the children's inheritance divorce proof is common. So that conversation usually involves, you've got 3 kids. Oh, one of them's been divorced. Maybe not. And so let's talk about making your children's inheritance divorce proof, because if you just leave it to them outright, the second they get it, it's theirs and theirs only. But if they mix it up or commingle it with other assets that they have with their spouse and then they get divorced, they may lose up to half or maybe even more of the inheritance. So what a lot of parents do is, they leave Timmy, and they do it for all three of their children, but I'll pick on Timmy here. They'll leave Timmy's inheritance because Timmy got divorced already. They'll leave Timmy's inheritance to what I call the Timmy Inheritance Trust for the rest of Timmy's lifetime. After the parents die, that inheritance will be held and titled in the name of kind of the Timmy Inheritance Trust. Maybe Timmy is the trustee of that trust and he can control that trust. In fact, usually when people do this, they name that child as the trustee of the child's trust. But what it does, it sets up Timmy's inheritance in a trust, makes it a lot harder for assets in the Timmy Inheritance Trust to be mixed up with other assets Timmy may have with his spouse. So if he does later get divorced, Timmy keeps all of his trust, and Timmy and his spouse split other assets that they may have accumulated during the marriage. So that's an issue for the 51 to 65-year-olds who have those young adults who are getting married. And like those parents tell me, I like my daughter-in-law, but the words I hear all the time, but you just never know. So I hear you just never know about the kind of divorce protection stuff all the time. Wish I had a nickel for every time I heard, Paul, yeah, maybe we should do that because you just never know. All right. So, and also now that your kids are in that young adult phase, you're 51 to 65, kids are young adults. Now you're starting to, really figure out who should handle things either when you get to a point during your lifetime where you're not able to transact for yourself or when you die. When your kids were minors, on your power of attorney, on your will as your executor, on your living trust, if you have one, as designating your successor trustee. When your kids were young, you didn't include your kids in any of those appointments. You probably designated your spouse first if you were married on your power of attorney, and then named some other close relative or friend as the backup to your spouse on that financial power of attorney, that healthcare directive or healthcare power of attorney, advanced healthcare directive. The executor of your will is probably your spouse if you're married, and again, another relative as the backup. And so now, as a pre-retirement person, someone who is 51 to 65 and whose kids have entered adulthood, now you can start adding your kids, one or more of your kids, to fill these roles. And so questions we always get, because you have two children or you have three children and you're like, yeah, well, of course, Paul, if I get to a point where I can't sign my name, I want my spouse to be able to have, I want to make it easy for my spouse to be able to do all that stuff. If a car in my name needs to be sold or an IRA in my name needs to be transacted, I want my spouse to do that. But then we always make people, we don't make them, but we suggest it and they always follow our advice. We always encourage people to designate a backup to your spouse, just in case your spouse predeceases you, or when you become incapable, your spouse is also incapable of transacting your business. So now it's, which kids do we want to designate? We're 51 to 65. We're in pre-retirement phase. Yes, we want to name our spouse first on all these designations, but which one of the children, or should we designate all of the children? Let me give you a couple of ideas here on the healthcare decisions. Some states call it a healthcare power of attorney. Other states call it a healthcare proxy. Some states call it healthcare directive, advanced healthcare directive. It's all basically the same. If I'm unable to go get my medical records, or if I'm in a surgery and doctors need to talk to people about treatment decisions, who do I want to give the authority to have all of that decision-making authority? Some people say, yeah, I want my spouse first, but let's name all three as the backups. So you got to be real careful about that. I'm being very general here. Some people don't want to be partial to certain children over other children. Got to be careful about that because you always want to make sure you have the right people designated, even if somebody might get their feelings hurt. Maybe you can have a conversation with them in advance. But on the healthcare side, and what I tell people sometimes is sometimes healthcare decisions need to be made quickly. So instead of saying all three of your children must work together to make your medical decisions, how about you say kind of any of the three children would be authorized if you have that confidence that they're going to talk to each other anyway. But but saying any of the three as opposed to all of the three together may be the wiser choice when appointing people on your healthcare power of attorney. On that financial power of attorney, some people, again, they want to designate two or more of their children. A lot of financial institutions don't like that because they don't like to have to work with two or more people on a power of attorney or as successor trustee or co-trustees of a trust. So I just know it's likely to be simpler if you designate, again, spouse first, and then maybe one of the children as the alternate agent, and then maybe another child as the backup to that child, or again, spouse first, and either of these two children would be authorized to handle your financial affairs if you can't. So anyway, there's some important decisions that need to be made there, as well as who's that. If you have a will plan where you leave everything in your name and your will covers who gets your stuff when you die, there's going to be a probate when you die. But if you have that will plan, who's going to be the executor of your will? It's an important designation because they're going to have a lot of power and control and authority. They can't change your decisions regarding who inherits from you, but they can impact the when they will inherit, whether assets in your estate will be sold, what assets are used to pay off debts. So they kind of lead the estate settlement process. So again, most married people appoint their spouse as their executor, one or more children as the alternate executors, but it doesn't have to be adult children. It can be someone else, but most people do designate one or more of the adult children as the alternate executor on their will after their spouse. Or in the alternative, if you've decided, like many people in the pre-retirement stage do, after having been through perhaps a difficult probate when their parent died, they're like, I don't want my heirs to go through probate. I want to set up that revocable living trust, transfer those assets that would be frozen and would have to go through probate if they were in my name when I die. I transfer them to my trust. Yeah, I can do whatever I want to with all the trust assets for the rest of my lifetime. But when I die, that trustee that I named to handle things when I die can then immediately start to handle the settlement of the estate without that court and lawyer involvement that the probate requires. So a lot of people choose that, especially in the pre-retirement stage, because they've perhaps been through one or more probates. They like the idea of streamlining their estate settlement by setting up that living trust to avoid the probate. Okay. That's the 51 to 65-year-old. And then our last phase of life is what I'm going to call the retirement and beyond. Maybe I should break that down into two phases, but let's just lump all those people into one big retirement and beyond category. That's the people, I'll call it age 66 and older. All right, so these people, they realize that they can't just kind of sit around and think about it anymore. These people realize, hey, it's time to get serious. I'm 70 years old. I've never done anything. They realize that they're not going to live forever. They really like the idea of avoiding the probate for an easy transition of the assets. Really important. They get serious about designating the right people to be in charge. Agent on the financial power of attorney, agent on healthcare power of attorney, who's going to be the executor of the will, who's going to be the trustee of any trusts that they leave behind. Now, I will say for some people age 66 and beyond, especially if they're not the mid to high net worth people who are 66 and beyond, some of those have concerns about what if they enter a nursing home. Some people, if I've heard it once, I've heard it 1,000 times. Paul, my father, he died a couple of years ago, but before he died, he went into a nursing home and he didn't have a whole lot of money. He had a couple of $100,000, but he had to spend it all. And he spent every last nickel of it, and he died with nothing. I know he wouldn't have wanted that. If he could have done things and planned in advance, he would have done some things to protect that money because he wanted to leave some things to his kids, lost the house, lost the car. So some people get impacted by family circumstances like that and want to be proactive. especially when they get to that maybe late 60s, 70s age range. And with the Medicaid planning, you can't do it when you're on the doorstep of the nursing home. Too late. So Medicaid planning, and look, we don't do much of that. Our kind of estate planning business really, our kind of sweet spot is those people with $2 or $3 million or more on up in assets. And those clients of ours who are in that sweet spot, they have no business doing any Medicaid planning and trying to position what they own so that they have less than $2,000 in their name if they need to go into a nursing home, so that they get the kind of care that the government provides to the indigent. Those people with 2, 3, 5, 10 million on up, they really need to be just private paying for and get the kind of care that they want and deserve, whether that care is in a very good facility or in their home or in somewhere else. So, but I will tell you, this issue is just on people's minds as they get into the late 60s and their 70s, particularly if they've had a family member go into a nursing home and have to, surrender lots of assets. So the key on that Medicaid planning, not that we do much of it, is you got to get things out of your name at least 5 years before you step foot in the nursing home. Because when you enter a nursing home, if you have a desire or your family has a desire for you to qualify for the Medicaid's long-term care benefit, because the nursing home, depends on your area, may cost $8,000, $10,000, $12,000 a month. So the idea there is when you go into a nursing home, you have, if you desire to have Medicaid pay for the nursing home, you've got to complete a Medicaid application, got to show that you have assets of less than $2,000, and you've got to show that you haven't made any transfers of assets out of your name within the 5 years leading up to your, entering into the nursing home and applying for Medicaid. So that's why you need to make these transfers at least 5 years before you go into a nursing home. That's why the people in their late 60s, their 70s are pretty hip onto trying to do what they need to do to qualify for Medicaid. So it's a different field. Many people are putting assets into very particular irrevocable trusts that they can't change in order to position themselves to be able to qualify for Medicaid if they enter a nursing home. But as we're talking about retirement and beyond, as we're talking about people age 66 and beyond, that's an issue for some of those folks. All right. And now, again, taxes become a big deal. I'm going to do some videos here upcoming, because as we get into 2025, most of the avoid taxes when you die discussions for people age 66 and beyond, most of the avoid tax when you die discussions start out talking about the federal estate tax. Well, shoot, that thing won't affect very many people at all. Now, when it does affect people, it hits hard. But with the numbers that we have for the year 2025, next year, a married couple can pass 20. I'm going to call it $28 million. It's really $27.98 million. $28 million of assets to their survivors without any of the 40% federal estate tax applying. If you're married and you have more than $28 million, yeah, there's a separate discussion that we need to have. But most of the people listening to this video, if they're married, the overwhelming vast majority of people have not hit that, or maybe anywhere close to that $28 million mark. We've helped a lot of people in the 100 million, 500 million, even $1 billion range. But those are not the majority of our clients, because that's not the majority of the American population. But so really, when it comes to those retirement and beyond discussions about taxes, there shouldn't, in most cases, doesn't even need to be a discussion about the estate tax or the gift tax. But there needs to be a discussion about the capital gains tax and the income tax, and that often gets overlooked. So really, for people 66 and beyond, having lots of discussions about the step up in basis, not only when the first spouse dies, but when the surviving spouse dies. I've even had some conversations in recent weeks about people doing some what I call upstream gifting assets to parents so that when the parents die years later and those assets get a step up in basis, which saved the children a ton of capital gains tax. So I think you're going to see in 2025 and beyond, and look, we don't know what our future estate tax law holds. We just had a presidential election, hasn't been inaugurated yet. We're likely to see a bunch of legislative proposals. I'll keep you posted. Nobody has a crystal ball. But with what we know now, married couples can shield $28 million from the estate tax. The shift now is clearly not away from, but less emphasis on avoiding estate tax, more emphasis on avoiding capital gains tax and properly using the step up in basis. And also with our relatively new Secure Act that applies to retirement account distributions after somebody dies, large emphasis on how can heirs minimize the impact of the income tax on those distributions when they are beneficiaries of traditional IRAs and 401ks. So that's the whole tax angle. You don't read or hear much about how the emphasis is shifting from the estate tax to the capital gains tax and the income tax from an inheritance standpoint, but no doubt about it, that's what should be happening. Also, as people 66 and beyond, you're seeing people get married later in life. Maybe they were divorced, maybe they lost their spouse, and they're remarrying. So lots of estate planning discussions about prenups. Because the spouses are getting married now. Each spouse has their own children. Each spouse has their own assets. Lots of discussions about prenups. Not so much, well, the discussion is relevant about what if we get divorced, but what's more on their mind is this: should we have a prenup to keep things separate so that when one of us dies, it's real clear what that deceased spouse's children's and the deceased spouse's surviving spouse, kind of what their rights are. A lot of people who get married later in life, they have their own children, they have their own assets, they want to keep things simple. Husband says, well, if I pass away, she has her own assets, those are hers, she can keep them. But I want to make sure if I pass away before my wife, I want my assets to go to my children. The wife may say the same thing. So lots about remarriage and prenups. Maybe some stuff about charitable giving when there is an interest, great ideas to, if you leave something to charity, leave it from your traditional IRA because the charity won't pay income tax on that. Whereas if you leave your traditional IRA, and for people who are 66 and older, they probably don't have 401ks anymore. They probably retired, rolled their 401k into their IRA. And if they have a charitable intent, maybe it's leaving things to the charity from your IRA because the charity won't pay income tax on it. Whereas if you leave your traditional IRA to individuals, they will pay income tax on it. So there's some good discussions there. Also, those people who are in that retirement and beyond, they're 66 plus, they probably, very generally speaking, have a handful of grandchildren. So lots of discussions. Hey, do you just want to leave your stuff equally to your kids or however you want to do it and, not leave anything directly to the grandchildren and just kind of keep things simple and let the children take care of their own children? Or do you want to carve some things out of your estate so that when you pass away, a certain amount of what you have, a certain percentage of what you have is carved out for the grandchildren because you want to make sure they inherit from you? Maybe you're concerned that if you leave it all to your children, they may spend it and nothing gets down to your grandchildren. Or maybe you just say, you know what, geez, my grandchildren have provided me with so much joy. I want them to get a head start on their life. Let's carve out something for the grandchildren. Maybe you have 3 children and 6 grandchildren. Maybe you say something like, I'm going to leave $100,000 to each of my grandchildren, the rest to my children. And if those grandchildren are still young, you'll leave their $100,000 in a trust, maybe designate their parent, your child, as the trustee, can be used for their education. And then the children get the rest of it later in life. Or maybe you leave them a certain percentage. Maybe you say, we want half of our estate to be divided among our 6 grandchildren. and we want half of our estate divided among our 3 children. So lots of different options there, but people 66 and beyond have those kinds of issues. I will carve out those kind of really old folks, and because we deal with this stuff a lot, I get the call, Paul, my mother's 92. She had a stroke, and the doctors say she doesn't have much long. She's in the hospital. Paul, can and look, she has a will that's 40 years old. Paul, can you redo everything? And my blunt answer is always, if I'm blunt, is always no. I don't want to push your 93-year-old grandmother whose capacity is diminished and who's lying on a hospital bed. I want her spending her final days with her family. I don't want her spending her final days being presented with a bunch of legal gobbledygook and having to answer a bunch of questions and then having to sign a bunch of legal documents where she can barely raise her hand. So that's my don't wait until it's too late, because I've turned away people who when we get that request for a family member who's, hate to say it, but on their deathbed, and that's not the time to be taking care of this stuff. Well in advance of that is the time to be taking care of this stuff. Okay, a few myths and conceptions or misconceptions about the estate planning process. Some people think estate planning is only for the wealthy. Well, you should realize, if you've listened to especially the early part of this discussion about guardians for minor kids, avoiding leaving things in a lump sum for financially immature people. Estate planning is not just for the wealthy. It's really for everybody. You're probably also hearing that, your estate plan may evolve over time. It's not a set it and forget it kind of deal. It's not a one-shot deal. As life changes and your circumstances change, it becomes important on updating things that you've done. And then maybe you're also hearing that trusts are just for the rich. And so again, if you heard the earlier part of this video, even if you're just starting to accumulate assets, even if you leave a child $50,000 or $100,000, it needs to be held in a trust for them. So you're avoiding a lot of the government bureaucracy that would otherwise take place when minors inherit. And then also just making sure whatever children, grandchildren might inherit, it's used properly regardless of the amount. So there we have it. Let me run through. We've got Larry here. Great. Got some highs. Got a lot of highs today. Okay. Thanks for the comments. Juxta, another hello from Tina. What if IRA named a beneficiary as a revocable trust? Is that a bad idea? Okay, so that's a good question. And what makes me pause before I try to answer it quickly is when someone has, let's call it a traditional IRA, that has all kinds of income tax consequences when the IRA owner dies. Sometimes you're not forced, but sometimes you kind of have to name a trust as a beneficiary if your beneficiaries either one are minors or number two, they can't handle money, and you feel like if you leave them a $500,000 IRA, by the next week they will have spent $750,000. So sometimes it's a lot because of the income tax aspects of being a beneficiary of a traditional IRA. I'll be the first to tell you, it's simpler when you name individuals as beneficiaries versus trusts as beneficiaries of IRAs. But if you're going to go the trust route, because you have to, whether that's your revocable trust or some other trust that you name as a beneficiary of your IRA, you want to make sure, again, here's the legal gobbledygook. You want to make sure that it's what's called a see-through trust. So the trust doesn't pay income tax on those distributions from the IRA after you die at higher trust income tax rates. You want it to be a see-through trust that meets the requirements of a see-through trust under our income tax regulations, so that you can look through the trust and then the beneficiaries of the trust pay the income tax on distributions from that IRA after you die at their lower individual income tax rates instead of the trust income tax rate. So Lots of other stuff involved, especially if you're leaving an IRA to a child and maybe you're not comfortable with that child getting all of that IRA money within 10 years after your death. Then there's more discussions that need to take place as to whether you want to leave that to what I'll call an accumulation trust so that you control what happens to your traditional IRA even for longer than 10 years after you pass away. So, of course, my answer is it depends, but it can be the right thing to do and it can be the wrong thing to do. What a terrible answer. Just depends on the circumstances. James, you're welcome for the information. Those feedback that you give me is always really, really helpful. I like to see kind of the positive reinforcement. So the end of this year in 2025 is going to be a big year for me with YouTube. It's just a way for me to get some information off my chest and share some experience with you, especially in this area of estate planning that a lot of people, it's, they get very little exposure to estate planning. And so maybe my channel helps out a little bit in that area. All right. Y'all have a great rest of the day. We'll see you next time. Got one tomorrow coming up. Thanks.